All right, hello. So last night we had our review, and we heard from a couple students that they're feeling, that they don't really know the Latin terms that are important for AP Gov. So we thought today we would just take a minute to walk through some of the terms. We've posted a Google slide on our review website of all these terms so that you can visit that. But we thought we'd just talk through some of the important terms that you need to know. So the first term is amicus curiae briefs, and we talked about this in the judicial unit. You can think of this as being friendly briefs, and it could be friends of the court. So think of that'll help kind of trigger what's needed to know about this. And it's not a litigant, so it's not someone who's bringing the actual case to court. Instead, it could be an interest group. It could be the president. It just simply means that they're going to write a brief to submit to the court explaining how they view the side or really stressing points that they want the court to consider. So again, amicus curiae, and that's like friends of the court and a friendly brief.
Then the next term is ex post facto. And ex post facto law is a power that is forbidden to Congress in Article 1, Section 9, and the power is denied to Congress. Basically what this is, would be a law that is passed that prohibits some type of action where you're holding somebody accountable for something that they've done, but it was not a crime prior to the law being passed. So for example, and this could also be used with punishment. So for example, if somebody winds up dealing drugs, and at the time that they committed the crime, it was a 20-year sentence. And then from the time of the crime being committed to their trial, there was a state law passed that made that crime now 50 years imprisonment. They couldn't hold that person accountable for 50 years in prison because it's after the fact. Or if they, for example, the other one I could think of would be, say, if driving with a cell phone was legal at a time and somebody got pulled over for speeding and they were on their phone, and then 2 days later they pass a law that says you can't be on your cell phone, you can't hold that person accountable, and so that's ex post facto.
Okay, so the next term is habeas corpus. I think this is a good one to give you the tip of Latin terms. So look to see what the root words are. So if you look at habeas corpus, we see that corpus sounds like corpse, right? Like a dead body or a body. And so you can think of this as holding someone without giving them due process. So you think of habeas corpus is the protection of unlawful imprisonment by the government. So the government can't just come to Mr. Erickson's house, throw him in jail, and not tell him what the charges are, not go through a fair trial. They can't have unlawful imprisonment. And so that's the protection of habeas corpus.
However, in some rare cases, such as during the Civil War or during 1944, presidents actually have denied habeas corpus rights. If you think back to, say, like the Japanese American internment camps during World War II. But that was obviously very controversial. The next term is quid pro quo, which literally means something for something. And this is typically a term that's associated in sexual harassment cases in the workplace, where a person who is in a position of power is asking a worker to do something, possibly to make an advance to go on a date or something like that, in exchange for possibly getting some type of, bumped up, get like a promotion, for example. And so quid pro quo is something for something, and again, it's commonly associated term with sexual harassment cases in the workplace.
So the next term is stare decisis. And so this term we've talked a lot about, especially when looking at how justices decide cases. And so stare decisis is basically let the decision stand. And it's if one of the three tools, it's saying that the court is going to use precedence. So the court is going to use what it has previously decided regarding an issue. So again, that's stare decisis, and that is using precedence, using what the court has already decided to then use it in a case in the future that comes forward. So remember, the three tools that we talked about are that obviously stare decisis, using precedents, using the Constitution, and then when we got into like judicial activism, we can see that sometimes they look at societal trends and societal issues to decide a case. So again, stare decisis, and that's let the decision stand using precedents.
And one of the main arguments with using the concept of stare decisis is that the argument for it would be that you're keeping decisions consistent over a course of time, so you're not getting away from the Constitution. Another term is en loco parentis. It does not mean crazy parents. It means in place of parents, and this is a legal standard that's used in schools, where it means that school officials, and when you're at school, the number one responsibility of the school is to keep you safe and provide a safe learning environment for you. And because of this, the school reserves the right to place greater restrictions on your constitutional rights. Although you have them, they're much more limited in a school environment. So, for example, a case like New Jersey versus TLO used this precedent in school searches, where they established that they can search based on reasonable suspicion, which is a standard that might be a little bit below something, say, like probable cause, or if the police or law enforcement have a search warrant. And so that's the concept of en loco parentis, or in place of parents.
Which is great, because we're your parents when you're here. Isn't that nice?
Yeah,
okay.
It is.
All right, the next term is writ of certiorari. This for sure will be on the test. You have to know the writ of certiorari, and it's pretty easy to know what the concept is. So you think of here as a cert petition is connected to this. So it could be the Supreme Court issuing a writ of certiorari to the lower court saying, hey, you need to send us all of the documents that are connected to this case. Send them to us. We're going to consider the case. Now, remember, in order for the Supreme Court to consider a case, they have 4 out of the 9 justices agree to put it on the docket. So they agree to hear the case. So the writ of certiorari is that process. If they do decide to not hear the case, they say cert denied, which means that they're going to send that to the lower courts and not have that being considered. So again, the cert is this process of telling the lower courts that we want to hear the case, and it's a part of a petition process, and it's that rule of 4 out of 9 justices to hear the case.
And typically speaking, the Supreme Court is going to take cases where there's inconsistency in the way that laws are either being interpreted or applied throughout the country. So, for example, if one appellate circuit rules one way on a particular issue, say like same-sex marriage, but then in another part of the country, another appellate court rules the other way on that, then that might be a situation where the Supreme Court looks at it and says we need to take this case because we have inconsistencies in either the way the Constitution's being applied or federal law.
And remember, there's thousands of cases that are petitioned to the Supreme Court, and obviously they can't hear all of them. So we're really going to look at like big issue matters. Okay. The next term is persona non grata.
Persona non grata is a Latin term which means unwelcomed person. And so as chief diplomat of the United States, which is the president being the main architect of our foreign policy, the president also, under this idea, the president gets to determine people who are unwelcomed people into the United States. This also kind of goes along a little bit with the idea of power of recognition of the president, where the president informally gets to determine which countries the United States will see as equals, legitimate equals, and who we're going to negotiate with. So, for example, what comes to mind would be President Bush not viewing the Iranian government as a legitimate entity that we are going to negotiate with, whereas the Obama administration has had a different approach to that.
And this really shows the power of the president, right? And so think back to all the different roles that we talked about that the president has. So looking at diplomatic influence that he has as persona non grata. The next are 2 terms that we link together, de jure segregation and de facto segregation. So again, these are terms that you look at the root words. So de jure is meaning by law. Okay, so this means that segregation exists because a law is there that creates the segregation. And so obviously we know through Brown v. Board and other cases, Plessy v. Ferguson, that when we're talking about de jure segregation, it's found unconstitutional. You can't have laws that are specifically segregating individuals from society. But de facto segregation still exists. And de facto segregation is segregation that exists by fact, just by happening to be where you live, for example. So if you look at like schools in the south side of Chicago, we could argue that they're very segregated. That's not because there's a law that says there's going to be segregation, but it just happens to be by the neighborhood that they live in. So again, that would be de facto segregation would be just how it exists in the world.
Right. Oftentimes you'll see this with say, like school district lines being drawn up a certain way. If you have, say, a school district that has 3 or 4 different schools, sometimes what could happen in the process is the district lines are drawn up in such a way where it's preventing certain groups of people from attending, one of the schools that maybe they want to keep a majority of the students Caucasian or whatever the case might be. And this, you see this in cities sometimes with the way that neighborhoods are drawn up. Chicago, in fact, would be one of the cities that really comes to mind with this. The next term is writ of mandamus, and this term basically is that the Supreme Court has the power to issue a court order that requests any type of official document, such as, say, like a contract, to either order a private institution or another government agency or Congress or even, in fact, possibly the president to issue this, and it's a court order demanding that they send a contract. Now, this was at the core of the Marbury versus Madison argument. The Judiciary Act of 1789 basically gave the Supreme Court the power to issue writs of mandamus to demand contracts. And so Marbury did not receive his contract, and so he requested that the Supreme Court, under the Judiciary Act, send the writ of mandamus to Madison and Jefferson so that they send his contract out for his position. And when it went to the Supreme Court actually struck this provision down, saying that the Constitution does not give the Supreme Court this power, but by doing that, they established the concept of judicial review.
Okay, and the last one, although it's not Latin, important form phrase to use is laissez-faire. And so we look at this in terms of the amount of involvement that the government has in business. And so laissez-faire is that feeling of hands off, that business wouldn't be regulated by the government. And so we look at like capitalism and the fact that, true capitalists do not want government regulation, so they want government to have hands-off approach, allow government to function and regulate on its own. And this definitely is something that when we look at political parties tends to be more of a Republican belief, that they want less government regulation. Or we could even say libertarians as well would say laissez-faire economics, that you would not have government regulation over business. So those are some of the terms that we think, will help knowing for the test, and they definitely are terms that we've seen over and over again on tests. So thanks for listening, and let us know if you need any help. Good luck, guys.
And I do not have a spotlight up on top of my head, just so you guys know.